Hey guys, it's Gary here with another legal tip about this termination fee. A couple of weeks ago, we talked about the fact that South Carolina Realtor Association has a new state contract out, how we overall liked it, but we had an issue with the termination fee. I'm not a big fan of termination fees, as I explained in that video. It's nothing against the Real Association that drafted or actually this contract. It's just the overall concept that we are seeing around the country. I know Charlotte, I believe, has a termination fee. I didn't like it in the Charlotte contract, so it's nothing necessarily against that particular drafting of the contract or how they did it. I'm just not a fan of it. Last week, however, I did put the other side out there because some people from the association, some agents who were fans of it, presented their side and why they're fans of it. So we went ahead and presented that side. So you would have both sides and you could decide whether you like the termination fee or not. And we also talked about how if you didn't like it, you could just put zero. There's no requirement there actually be a dollar amount. Now, this week, we're going to talk about some issues we've seen with the actual termination fee. And what we're seeing is apparently there's some lawyers up in Greenville who believe that they have to open up an escrow account to hold these termination fees. I'm baffled by that position. And the reason I'm baffled by that is the contract under paragraph 8 says termination during the due diligence period, buyer may unilaterally terminate this contract only by delivering to the seller both the notice of termination and the termination fee. It doesn't say delivering the termination fee to the closing attorney, the buyer's attorney. That does not effectively terminate the contract. So to terminate the contract under the plain language of this contract, paragraph 8, the contract termination fee and notice has to be delivered to the seller. Now, who's the seller? Well, it'd be the actual party, the seller, or their agent as an extension of them under their agency laws. And so you could deliver it to either the agent, the seller, or the agent's brokerage. You can go deliver it to their broker in charge, and that's the same thing as delivering it. But delivering it to the buyer's attorney is not going to be an effective termination. So I don't understand why they're talking about holding money in escrow. Second of all, you're not holding termination fees because you don't have a termination fee unless they terminate. So when your client signs the contract with an earnest money check, they don't also sign the termination check in anticipation of the termination. The termination check only comes if they decide to terminate. They then sign the termination form and then they sign the check and send the check. There's no reason to collect that termination fee at contract signing. It's only if they terminate. So there should not be a check out there. Thirdly, because the check is payable to the seller, why would any closing attorney or brokerage for that matter deposit the money in their escrow account? I don't know how they would deposit in the escrow account because the check's made payable from buyer to seller. So how are we depositing a check that's not even made payable to us in our account? If the client deposits a check with us, let's say they for some reason made it payable to your brokerage or made it payable to the attorney, and we do deposit in our account, you and I have to wait 10 days for that check to clear the bank because you can't disperse it, nor can I disperse it until we have good funds. And 10 business days takes for the check to clear the bank. So that would probably be outside of the due diligence period anyway. So them giving the check to the attorney or giving the check to you, payable to you, is not an effective termination. The check's payable to the wrong person, and the check's now going to be held for 10 days for it to clear the bank. So the only thing that needs to happen is when they decide to terminate, they then sign the release form. They then provide the money for the termination, and that check is delivered, or that money and that termination fee or that termination document would be delivered to the seller, either to the seller directly or to the seller's agent or broker. That's it. There's no reason that you nor I would be holding that money, nor could we, because the money should never be made payable to us. So I'm really baffled at why they're saying that they have to open up escrow accounts. Now, the only thing I could come up with is if your client's in California and they're concerned if they cancel, they won't be able to get the money here in time is through Venmo or wire to the seller or whatever. The only other option they would possibly have, I guess, is they could go ahead and pre-write the check, give it to you. But again, the check's going to be made payable not to you or me to hold an escrow, because that's not how it's going to work. It'd be made payable to the seller. And I guess you as the agent could hold that check, and if they decide to terminate, present the check to the other side. If not, tear it up and give it back to your client. Now, remember, under 4057, you personally can't hold those checks. You would have to give that check to your broker, not to deposit in the escrow account, but for your broker just to hold in a strong box or a locked desk or somewhere of that nature until it's ready to actually be handed over to the seller or torn up. But that's the only time anybody should be holding a check, is if they wanted to go ahead and give it to you in case they are terminating and they're not going to be here to write the check. But again, that check's not payable to your brokerage. That check's not payable to our law firm or any law firm. That check's still payable to the seller, and all you're going to do is hold it. And you're not putting it in an escrow account. You're just holding it in a locked office, or your broker is, or a locked safe until it's ready to go. So that's it. I'm not sure why anybody thinks they need to open an escrow account. I don't know why anybody thinks they need to hold escrow, but that's basically the gist of it. If you got any questions, reach out to me at Gary at Blair Cato, and look forward to seeing y'all soon. Y'all take care.